The Senate Health, Education, Labor, and Pensions Committee will please come to order. Thank you, Chair Murray, for calling this hearing today, and I appreciate the opportunity to fill in for Chair Murray. And in addition, thank you to Senator Burr for working closely with Chair Murray to get this hearing planned. And for working with these two nominees, Senator Burr is also unable to be here today, but I'm very pleased to have Senator Braun as the ranking Republican today. We are holding a hearing on the nominations of Jessica Luman to serve as the administrator of the Wage and Hour Division of the Department of Labor, and Carla Gilbride to serve as the general counsel for the Equal Employment Opportunity Commission. Ranking Member Braun and I will each have an opening statement, and then we will introduce the witnesses. After the witnesses have given their testimony, senators will each have 5 minutes for a round of questions. While we are unable to have the hearing fully open to the public or media for in-person attendance, live video is available on our committee website at help.senate.gov. The video on the HELP Committee's website will have closed captioning. If you are in need of other accommodations, you can reach out to the committee or the Office of Congressional Accessibility Services. We received Ms. Luman's formal nomination on July 28th, her Office of Government Ethics paperwork on August 3rd, and her committee paperwork on August 18th. And we received Ms. Gilbride's formal nomination on June 7th, her Office of Government Ethics paperwork on June 23rd, and her committee paperwork on July 11th. I'd like to thank all our witnesses for joining us and also to welcome their family members who are here today, Ms. Luman's husband Jason and sons Jack and Joshua, and Ms. Gilbride's husband Mark and mother Janet. Welcome. I'm very happy to have before us two nominees with strong records of representing the interests of workers. Jessica Luman has very ably served as the Principal Deputy Administrator of the Wage and Hour Division since January of 2021. In recognition of her excellent service, Ms. Luman has been nominated to permanently lead the division at the Department of Labor, and I can't think of a better candidate for this role. I've had the pleasure of knowing and working closely with Jessica since 2011. And I'm confident that she will be a fair and pragmatic administrator as she enforces some of our nation's most important labor laws, including laws covering minimum wage, overtime, and child labor. And this is the role that has real impact for working people, like the waitress who should be protected from a boss who steals her tips, the building trades carpenter or laborer who has the right to earn the prevailing wage that can support their families when they work on federal contracts, and the worker who has the right to earn overtime but isn't being paid for those hours worked. Ms. Luman's values are rooted in upholding the dignity of work and supporting everyday, hardworking Americans. And all the time that I've known her, she has approached issues with a keen desire to understand both sides of the argument and to find the fair solution that both sides can understand. This is why she is respected by both employers and labor, first in Minnesota and now in her work at the U.S. Department of Labor. Ms. Luman is respected because she is reasonable and she builds consensus, even when it's difficult and there are real differences to bridge. Ms. Luman is an expert in her field and a strong listener. These are qualities that will serve her well and make her a great wage and hour administrator for workers and employers across the country. Our second nominee is Carla Gilbride, who has been nominated to serve as the General Counsel for the Equal Employment Opportunity Commission, the EEOC. Carla Gilbride is currently a co-director of the Access to Justice Project at Public Justice, a nonprofit legal advocacy center. There, she leads litigation on issues related to workers' rights and access to justice. Her work experience and background in litigation on these matters makes her highly qualified and well-suited to lead the Office of General Counsel at the EEOC. This office at the EEOC conducts litigation in service to enforcing our country's employment discrimination statutes. These discrimination laws, which affect virtually all Americans, include Title VII of the Civil Rights Act, the Americans with Disabilities Act, the Pregnancy Discrimination Act, the Equal Pay Act, the Age Discrimination and Employment Act, the Rehabilitation Act, and the Genetic Information Non-Discrimination Act. These laws offer crucial protections for people in connection to their employment, to close the gender pay gap and other pay inequities, to shut down workplace harassment and discrimination, and to protect the rights of workers in their workplaces. Congress created the EEOC to protect workers through these anti-discrimination laws, and the Office of General Counsel at the EEOC plays a central role in delivering these protections. I am very confident that Ms. Gilbride's background and experiences will serve her very well in this role. Before I turn to Ranking Member Braun for his opening remarks, I seek unanimous consent to put into the record a statement for the record from Chair Murray, 7 letters in support of Ms. Luman's nomination, and 5 letters in support of Ms. Gilbride's nomination. Without objection, so ordered. I'll now turn it over to Senator Braun for your opening remarks.
Thank you, Madam Chair. Before coming to the Senate, I spent 37 years in my hometown building a business that started as a real little one that evolved into a national company. When you do that and you live on Main Street, your employees are your friends and your family. And I think it's so easy that companies that do grow, especially when they don't get too corporate, when they get detached from maybe what got them there in the first place, it's a different dynamic. And we had that conversation a little bit, prior to this hearing today. I know firsthand that the burden that the federal government can put on a small business in just making payroll can be significant. And the other thing you got to realize is that small businesses, they are earning a living mostly in that small business as a paycheck, and they're providing jobs to boot. So it's technically a much tougher kind of dynamic than it would be in just working somewhere. And I want to make sure whatever we do is that we don't throw cold water on that or make it to where we discourage entrepreneurialism and what happens on Main Street. Big difference between Main Street and corporate America, in my opinion. When it comes to how government interacts, I think there's a place for having common sense regulations where employees, when they are not treated in a way where it's like family, friends, where you're not giving good wages, benefits, and a good long-term future there, or especially, we were in a hearing earlier this year in the Budget Committee, and it related to the issue of unionizing Amazon. Of course, you have, in that case, higher than normal accident rates, higher turnover rates, and when you're maybe bragging about the fact you're paying a $15 an hour wage, I think we need to aim higher than all of that. And I think there's a place for that interjection of government. But when it comes to what drives this country, what makes it what it is, it's Main Street America, it's that small grassroots economy, and most of the people there, remember, are making their living out of that entity. So we don't want to do anything that suppresses it. Today we're considering the nominations of Carla Gilbride for General Counsel of the Equal Employment Opportunity Commission and Jessica Luman for the Administrator of the Wage and Hour Division of the Department of Labor. We had a, I think, lengthy conversation in how recently where that attempt was to move that salaried position from a figure of like 27,000 ended up at 36, but then got proposed being as high as in the 70s or 80s. That would completely disrupt and ruin the dynamic that many small businesses have to live with, acknowledging too that if you're on a salaried pay system, that there are certain things that maybe are different from it versus being a waged employee. I want to make sure that during the Trump administration, we tried to take a little bit of the burden off of Main Street, that we don't add back to it, conflating the need that might come from that dynamic of huge companies with their employees versus small business in Main Street with theirs. Commission could reverse, reverse some of this stuff, and then you involve litigation. Then you make it strenuous. A lot of that marginal difference in having to fight things that you're not necessarily needing to fight because you're doing a good job anyway can be the difference between staying in business and going out of business. The chair of the commission also has made clear that she will seek to reinstate burdensome collection pay data from employers in an attempt to identify pay discrimination. However, the reality is that this data provides no context for the wages, such as job experience, education, or skill level. This collection will force employers to shoulder additional costs and require significant changes in their HR systems, and again, will have a disproportionately burdensome effect on smaller companies. As wage and hour administrator, Ms. Lumen would be charged with the enforcing of the Fair Labor Standards Act, which is the federal statute dictating minimum wage, overtime pay, record keeping, and child labor requirements for private employers. As acting administrator, she oversaw the end of some of the things that Trump administration did, and we talked about that before this hearing as well, that we shouldn't just get rid of carte blanche if there's some common sense to it. The Biden administration is working on their own version of these rules, which I'm concerned will be somewhat job-killing, burdensome, and bring uncertainty to employers, employees, and entrepreneurs. Based on the previous conduct, I'm concerned that the White House will attempt to circumvent Congress to implement aspects of the PRO Act. And if you tried to do this wholesale, I think, again, you're tampering with the grassroots dynamic of what makes this economy tick. There are solutions Congress can implement to help the government work with employers to create a better and fairer workplace, bona fide goals to aspire to. For example, the Ensuring Workers Get Paid Act, which codifies the payroll audit independent determination pilot program, is one of them. This program gave employers a way to proactively fix inadvertent overtime and minimum wage violations without the heavy hand of audits and litigation and so forth. We need to keep that in mind because I think most small employers really like that before you get into a full-fledged regulatory discussion. President Biden ended the program upon taking office, and this bill would reinstate it so we can work together with employers rather than continue the top-down, one-size-fits-all approach that it looks like we're now entering into. Thank you, Madam Chair.
Thank you, Senator Braun. I will now introduce today's witnesses. First, we have Jessica Lumen. Jessica is from St. Paul, Minnesota. Thank you to you and your family for being here. Jessica is a longtime labor leader, attorney, and lifelong champion of workers. Prior to joining the Department of Labor last year, Jessica led the Minnesota State Building and Construction Trades Council, which represents more than 70,000 union members working in 15 construction trades. In that role, she worked to secure funding for key infrastructure projects, fair wages and safe working conditions for workers, and a strong Minnesota economy. Jessica is a strong advocate for working people, and she's also thoughtful, innovative, and fair in working with a variety of stakeholders. I know this because Jessica and I were able to serve together in state government for nearly 7 years. We began working together when I was Minnesota Governor Mark Dayton's chief of staff. She began as an assistant commissioner in the Minnesota Department of Labor and Industry and impressed us all. And she then was promoted to deputy commissioner before being named commissioner of the Minnesota Department of Commerce, which oversees energy, insurance, and financial services in Minnesota. There she led a number of successful initiatives to help support domestic energy, grow the state's economy, and support workers in business. Jessica received her bachelor's degree from George Washington University, her law degree from the University of Minnesota. She is a 24-year member of LIUNA. As I said at the beginning of this hearing, Jessica is an excellent pick to lead the Wage and Hour Division, and I can't think of a better nominee. Our next witness is Ms. Carla Gilbride. Ms. Gilbride is an attorney and leader focusing on defending the rights of workers. I know you were also joined by your family today, and it's wonderful to have you all with us. Ms. Gilbride is currently the co-director of the Access to Justice Project at Public Justice, a nonprofit legal advocacy organization. There she has successfully argued in front of multiple U.S. courts of appeals on the topic of arbitration and recently won a unanimous Supreme Court decision in Morgan v. Sundance, which held that courts cannot favor arbitration agreements over other types of contracts. She has a record of fighting for meatpacking workers, people with disabilities, warehouse workers. Prior to joining Public Justice, Ms. Gilbride served as an associate at Melry and Scalet, PLLC, where she worked on wage and hour, employment discrimination, consumer class action, and Fair Housing Act cases. Before that, she spent several years at Disability Rights Advocates, representing disabled consumers in discrimination class actions. Ms. Gilbride is from New York, and both her parents and grandparents were lifelong New Yorkers. She went to public school in Long Island, and her father was a state employee. Ms. Gilbride received her bachelor's degree from Swarthmore College and her law degree from Georgetown, where she served on the Georgetown Journal of Poverty Law and Policy and graduated with honors. Following her graduation from law school, she clerked for Judge Ronald Gould of the U.S. Court of Appeals for the Ninth Circuit. I'm confident that her skills and experiences make her well prepared to serve as the General Counsel of the EEOC, and I look forward to supporting her nomination as well. Thank you very much, and we will begin with Ms. Luman with your testimony.
Thank you so much, Madam Chair. Thank you, Ranking Member Braun, and the members of the committee that are here today. I appreciate very much the opportunity to appear, and I particularly want to thank Chair Smith for the very, very kind introduction. I also want to thank my husband, Jason, and my sons, Jack and Joshua, who are here with me today for their ongoing encouragement and support. I am honored and grateful for President Biden, Vice President Harris, and Secretary Walsh's faith in me, and I appreciate your consideration for my nomination to serve as the Administrator of the Wage and Hour Division of the U.S. Department of Labor. As Senator Smith shared, my family and I are from St. Paul, Minnesota, and since January 21, I have served as the Deputy Administrator for the Wage and Hour Division here in Washington. And I am proud that every day I get to wake up and help 148 million workers across our country and 10 million employers. I, like many of you, were inspired to public service by my parents. My mother, who passed away in 1999, was active in our community. She worked for the Red Cross and the Cystic Fibrosis Foundation, and she was passionate about making sure that everyone, and especially women, were able to vote. My dad, who was a locomotive engineer and a union steward when I was little, also served in the Ohio state government. My dad especially taught me that hard work and workers are the foundation of our society, our economy, and our community. And he's pretty proud of me right now. Last year, I came to the Wage and Hour Division after 2 years as the Executive Director of the Minnesota State Building and Construction Trades Council, which represents over 70,000 union construction workers in that state. In that role, I partnered with employers and advocates for more construction investment. I worked to expand construction career pathways and increase the number of women and people of color in the Minnesota construction industry. In 2017, I was appointed by Governor Dayton as the Commissioner of the Minnesota Department of Commerce, where I worked with the energy, finance, and insurance industries to expand investments in domestic energy production, focus on consumer protections, and address insurance fraud. And as Deputy Commissioner of the Minnesota Department of Labor and Industry, I oversaw the operations of the agency as well as the labor standards, construction codes, and apprenticeship programs. I was proud to oversee some of the most impactful efforts to streamline licensing and increase opportunities to expand registered apprenticeship into healthcare, agriculture, and IT industries. Throughout my work with the Minnesota Building Trades and my time with the Minnesota Departments of Commerce and Labor, I have worked on issues of critical importance to businesses and workers. In each of these roles, I made sure to listen and learn from business, worker, government, and other leaders. And I have consistently found that listening to all points of view has made me a better leader too. My parents, mentors, and colleagues have all inspired me to work hard, to collaborate, build consensus, and develop opportunities and create economic security for working people across our country. And I've worked with employers to do it. Nowhere is this better illustrated than the construction industry, where I've spent over half of my career. Because building trades workers only work when their construction contractor employers have projects, it is critical that labor and management partner together to advocate for infrastructure investment, to ensure the safety of construction workers, and to expand diversity and inclusion in the industry. I bring those lessons to my state and now my federal government work. As Commissioner of the Minnesota Department of Commerce, I prioritize providing certainty for the financial, energy, and insurance industries. And at Labor and Industry, I provided construction, manufacturing, and healthcare industries, helping them to work to meet their workforce needs and their labor standards responsibilities. I recognize that helping employers understand the law is a key part of helping businesses, consumers, and employee and working families thrive in our economy. And that most employers want to understand and to comply with the law. And to support responsible employers and all working people, we must focus on protecting the most vulnerable among us, because it hurts both workers and employers when workers become victims of wage theft, retaliation, and exploitation. In America today, we are seeing workers who are not getting paid the minimum wage and the overtime they have earned, and children working in dangerous occupations. And we know that workers are still fired, threatened, and worse because they act to be paid for their work. If confirmed, I am committed to helping to prevent wage and hour violations from happening through outreach, education, and compliance, and to ensuring that violations that do occur are remedied and workers are made whole. It would be a privilege to serve. Thank you.
Thank you, Ms. Lumen. We'll now hear from Ms. Gilbride for 5 minutes. Thank you.
Thank you. Chair Smith, Ranking Member Braun, and members of the committee, I'm honored to be here today under consideration to serve as General Counsel of the U.S. Equal Employment Opportunity Commission. I'm deeply grateful to President Biden and Vice President Harris for nominating me for this role. And I'm even more grateful to the people in my life who helped me get to the place where that nomination was possible. The first of those people can't be with us physically today, but I know he's here in spirit, and that's my father, James Gilbride. My dad taught me by example about the nobility of service, starting with his service to this country in the military, followed by a career in law enforcement. And he taught me through his quiet, steadfast presence that showing up, working hard, and treating others with respect are virtues worth emulating. My mother, Janet, is here today. From her, I learned from an early age about leadership and about taking the initiative to address unmet needs. I was born with an eye condition that caused me to be totally blind. My mom looked around for support groups for parents of blind children in Long Island, New York, where we lived. And upon finding that there weren't any such groups, she started one. She also took on leadership roles within our church and school district, and many evenings during my childhood, she presided over meetings at our kitchen table. Like many parents, she was a fierce advocate for her child, making sure that I had the same educational opportunities that my sighted peers did. But she broadened those efforts beyond her own family to advocate for other students with disabilities as well. Also with me today is my husband, Mark Faulkner, one of the smartest and most generous people I've ever known. Mark is not a lawyer, and while I'm most comfortable in a world of words, he's happiest when working with his hands or with data and electronics. Our differences and the joy he takes in doing things I'm not good at and don't enjoy remind me every day how important different skills and perspectives are. Our differences make our partnership work, and my life is richer in countless ways because he's part of it. I am grateful beyond words for his support over the years, and I'm grateful that he's here today. Other people also set me on the path that made this nomination possible. Teachers who instilled a lifelong love of learning and propelled me to excel as a first-generation college student and then go on to law school. Role models in the disability rights and women's rights movement who dared greatly and gave me the courage to dare more while standing on their shoulders. And my current and former employers who mentored and supported me as I gained skills and confidence as a lawyer. Throughout my legal career, I have always sought to open pathways of opportunity to those with less money and fewer societal advantages. I have represented restaurant workers, truck drivers, people who endure dangerous conditions in meatpacking plants, and people who use wheelchairs and just want the same transportation options as everyone else. Along the way, I've learned a great deal about litigation, but also about how to effectively communicate and find common ground. I've learned that by listening closely to everyone I interact with, I will learn, I will grow, and I will form relationships that matter. And I can't think of another government agency where using the legal experience and interpersonal skills I've acquired over the years would mean more to me than the EEOC. That's because the laws that the EEOC enforces represent some of this country's greatest ideals, that everyone should have opportunities to reach their full potential in the workplace, free from barriers caused by bias, harassment, or a failure to accommodate their religion, their pregnancy, or their disability. If I am so fortunate as to be confirmed to serve as general counsel at this agency, I will work with the commissioners, the regional attorneys and agency employees, employers and their representatives, and those who file charges of discrimination with the agency to bring those ideals closer to reality. I recognize that the position I've been asked to fill entails challenge and complexity. I welcome the challenge because I believe in the EEOC's mission with every fiber of my being. And I welcome the complexity because I know there are many valuable and diverse perspectives with a lot to teach, and I'm eager to learn. Thank you again to the committee for your time and consideration today, and I welcome your questions.
Thank you very much to both of our nominees, and we will now begin a round of questions from members of approximately 5 minutes each. And I'll begin with a question to Ms. Luman. Ms. Luman, you have a strong background in labor. I'm very proud of that background for a good reason. In your time working in Minnesota and now in Washington, I know you have also made it a priority to listen to both sides of an issue and to build relationships and open dialogue with both workers and employers. So could you talk a little bit more about that value that you have? Why do you think it's so important to listen to everyone when you're making policy? And could you expound a bit on how you've worked with a wide variety of stakeholders, including businesses and employers, in addition to representatives from labor?
Thank you, Madam Chair. I appreciate the question. I absolutely agree and recognize that in order to have an effective labor standards program for this country, that we need to recognize that we are both protecting working people and we are helping serve the employers who provide them jobs every single day. And the way we do that and the way I think about that work, I mean, I've always thought about that work, whether it's in Minnesota state government or when it's working, advocating for union construction workers or now at the Wage and Hour Division. The way I always think about that work is that first and foremost, our goal is to prevent wage and hour violations from ever occurring in the first place. When we work together, when employers understand their responsibilities, when workers understand their rights, then we, through outreach, education, compliance, we can make sure that those violations never occur. And that's just one of the most critical issues, is that success for the Wage and Hour Division, and frankly success for our economy, is that workers are paid correctly every time on payday. So through prevention, we can really work together to make sure that employers and workers and unions are coming to the table, having a conversation, and understanding what the obligations are and how to achieve those as quickly, as efficiently, and as productively as possible.
Thank you very much. I want to hone in a little bit on the issue of wage theft, which is something that I'm greatly concerned about. I think it's really surprising for people to understand that wage theft is so pervasive that according to one estimate, it accounts for nearly 3 times as much lost money as robberies. And wage theft, of course, can take many forms, whether it's making employees work off the clock, denying overtime pay, stealing tips, knowingly misclassifying your workers. And I think we would both agree that many employers treat their workers fairly and do the right thing, want to do the right thing when it comes to compensating their employees. Yet, we also know that there are examples of employees being taken advantage of. So, Ms. Luman, if confirmed, what will you do to combat this issue of wage theft? And can you give us an example or two of why this is so important?
Thank you, Senator. Absolutely. Wage theft is one of the most critical issues, and it is foundational under the Fair Labor Standards Act that workers get paid the minimum wage and the overtime, a minimum wage for every hour that they work, overtime when they work over 40. Since I've been with the Wage and Hour Division, we have collected over $343 million in back wages for 279,000 workers. Again, those are folks who didn't get paid correctly on payday. I think the reason that this is so prevalent and such a critical issue is because it's not just about impacting industries and sectors. This is also the impact on individual workers' lives. And I was in Columbus, Ohio a few weeks ago and was talking with an investigator at the Wage and Hour Division, and he was telling me about the impact that he was able to make on one worker's life when he was able to return $200 that she should have gotten on her paycheck, was able to return $200. And he asked her what she was going to do with that money. And she said, I'm going to call my grandchildren. I usually see my grandchildren on the weekends, but I haven't been able to buy them food for the last 3 weeks. and I haven't been able to see them, and the first thing I'm going to do is call them and invite them to my house, and then I'm going to go to the grocery store. That makes the difference, and that $200 makes the difference to that worker and that family, and that's what we have to prevent. We have to prevent wage theft to that worker.
Thank you very much. Thank you. Ms. Gilbride, I so enjoyed the opportunity to meet with you in our discussion last week and appreciated hearing about your experience and your personal interest in this role. I want to just give you an opportunity to expand on that briefly, and could you just talk to us about what you connect to in the mission of the EEOC and what you think will be so important as you approach this important role?
Question. The mission of inclusion and of allowing workers to be judged on their merits and not on aspects of their identity like their race, their sex, their religion, or their disability is something that I have practiced and focused on throughout my career as a civil rights lawyer representing workers, but it's also something that I feel very personally as a woman, as a person with a visible disability. I have been fortunate to have had wonderful employment opportunities throughout my career, but I've also applied for jobs that I didn't get. I've had interviews where I did feel that my disability was, perhaps an elephant in the room, and I've talked to many friends, many people that I know well in the disability community who have similar experiences. Or I have friends who are attorneys of color and who have had potential clients, say to their face, I would be more comfortable working with a white lawyer than with you. And those experiences of being treated as less than, of not being trusted, of not being given opportunities because of immutable characteristics of race, of sex, of disability is something I feel very strongly about, something that's very personal to me, and I would do my best to bring my experiences and my legal skills to bear to make sure that the ideals and the mission of equality of opportunity that led Congress to pass the anti-discrimination statutes that the EEOC is now charged with enforcing. That mission is something that is very personal to me, and I would make sure that Congress's laws, as interpreted by the Supreme Court, are enforced by the Commission if I am so fortunate as to be confirmed as General Counsel.
Thank you very much. Senator Braun.
Ms. Luman, I've got 3 questions for each witness and kind of pace the answers accordingly. I got a little 5 minutes or just a hair over. The PRO Act, which passed the House, does not look like it's going to make it through the Senate, had a couple really significant items within it. It would be expanding the joint employer standard and further fleshing out the definition of independent contractor, including the ABC test, which I think you're familiar with. My question is very simple. Do you think the Department of Labor has the authority to wade into either one of these discussions, or do you think that is the bailiwick of us here in Congress?
Thank you, Senator Braun, and I will try to keep my comments short. The PRO Act is very much supported by President Biden in terms of how Congress can help move forward with thinking about worker protections and worker organizing in this country, which is empowering workers. From the perspective of the Wage and Hour Division of the Department of Labor, we continue to look at implementing and enforcing the Fair Labor Standards Act as passed by Congress. And that means that we do look at issues related to the employer-employee relationship as it impacts whether workers are earning minimum wages and overtime under the law.
So does that mean you would be for looking at particularly doing something to change the ABC test or expanding the joint employer standard guidelines? Is that something that is actually something Congress should do, or can you do it administratively?
Thank you, Senator Braun. Related to the ABC test specifically, the Wage and Hour Division and the Department of Labor do not have the authority to adopt by regulation the ABC test unless it's changed by Congress. We do have the responsibility of ensuring that workers are not misclassified as independent contractors, and that is very much a focus of ours in the Wage and Hour Division, and that's determined on a case-by-case basis, not utilizing the ABC test.
Sounds like with the former, you think it does not have the authority, and on the second one, when it comes to independent contractors, you would get involved in maybe the more routine part of what you'd come across as opposed to charting new territory. Second question, the gig economy, which is something relatively new. Tell me what you think about it. And of course, that's in that tricky category of independent contractor, one-person business, and the fact that it has exploded in terms of options, again, for people to earn a living. To me, the same thing is getting a paycheck from an employer. Plus, again, all the risk of running your own business. Tell me what you think about it, and how would you navigate accordingly?
Thank you, Senator Braun. The way that individuals are employed is, again, a case-by-case determination that we make in the Wage and Hour Division when we're looking at whether or not there have been violations of the Fair Labor Standards Act. And we particularly recognize and understand that legitimate independent businesses have an incredibly important role in our economy. And at the same time, we want to make sure that workers that should be getting the basic protections of minimum wage and overtime are getting those protections. And so we apply the law based on the cases and the facts that we have, and determine whether or not any individual worker should be getting those protections under the law.
One final question. Department of Labor is considering the threshold for overtime exemptions. Mentioned it earlier in my opening statement. Some have called for a level up to or slightly above $80,000. What is your opinion on where that should be?
Thank you, Senator. Overtime is one of the foundational and most important issues that we look at in the Wage and Hour Division. And as you know, the exception from the wage and hour protections for workers who are characterized as executive, administrative, or professional employees, there's a salary.
What about the level? I know all of that. What is your opinion on where that level should be? Because that's the thing that's everybody's worried about, not the concept of it.
Absolutely, and that level does matter because, again, it is when you make...
Do you have an opinion on where that level should be?
So we have been listening to industry. We've done over 27 listening sessions with over 2,000 participants, really to get to that issue of what is the appropriate level for workers who are going to be excluded from protection.
It sounds like you're still working through that. So to me, I think most, like I said earlier, if it would get into that higher altitude area, it would be disruptional both for employees and employers. Ms. Gilbride, in a recent Wall Street Journal op-ed, Commissioners Dillon and Sonderling expressed concern that the commission was being undermined by a power grab from the staff, which is refusing to formally close proposed lawsuits that the majority of the commission has voted down. Do you agree that only the commission by majority vote can authorize litigation, and the general counsel and staff should defer to the commission's decision?
Thank you for the question, Senator Braun. I understand that the delegation of litigation authority from the commissioners to the general counsel is something that has evolved over time at the agency, and if I am so fortunate as to be confirmed, I would want to speak with all of the stakeholders, including Commissioners Dillon and Sonderling, as well as the career staff at the agency who have a lot more understanding of how the delegation authority has played out over time, and based on those perspectives, I would gain a more informed opinion than I do now as an outsider, which is only what I read in the news media.
Final quick question related to that. Do you think it is appropriate for the general counsel to take a litigation position that does not reflect the majority view of the commission?
Well, if I have the opportunity to serve as general counsel, I would certainly work closely with the commissioners and attempt to gain consensus. Again, I would follow what the current delegation of authority is with respect to seeking commission approval for engaging in new litigation. But aside from whatever the formal policy of delegation is, I think it's simply a good practice to work closely with all affected stakeholders, and I would want to understand what the commissioners' views were if we had a difference of opinion, to try to work through that through productive dialogue to hopefully reach consensus.
Thank you so much.
Thank you. Senator Murphy.
Thank you very much, Madam Chair. Thank you to both of you for your willingness to serve. I had just one topic that I wanted to raise with you, Ms. Lumen, and that is the issue of non-compete agreements. There's a growing body of literature, frankly, both on the right and the left, that shows one, the massive explosion of non-compete agreements, both for high-income workers, where we tend to think non-compete agreements exist, but also low-income workers. Today, it's estimated that somewhere between 20, maybe as high as 30 or 40% of American workers have these non-compete agreements. The vast majority of them are not negotiated. And in fact, maybe as high as 30 to 40% of these non-compete agreements are signed after the employee starts the job, when they have very little leverage to refuse it. In Connecticut, we're hearing about these non-compete agreements being used for very low-income home care workers. Of course, there's the famous instance of Jimmy John's sandwich shop requiring its workers to sign non-compete agreements and then denying them the ability to go work for another franchise of Jimmy John's because it was owned by a different ownership group. These non-compete agreements, they depress wages, they hinder entrepreneurship, and we have a good bipartisan consensus growing in the Senate to restrict their usage. Senator Young, Senator Kramer, Senator Kaine, and myself have introduced legislation that would make them broadly impermissible with certain common sense exceptions. I know Senator Rubio and Senator Hassan have introduced more targeted legislation to restrict their usage for lower income workers. The President has put out an executive order sort of starting to enter this, put the administration more firmly on the side of workers. What can the Wage and Hour Division do? What role can the division play in reducing the proliferation of these harmful agreements? What's the sort of boundaries of what the law allows you to do today? What additional authority might you need from Congress?
Thank you, Senator. We, too, are concerned about, and again, in my role as the Deputy Administrator, but also in my previous roles, we are concerned about issues that would impact workers in terms of either the wages that they earn today or also from any chilling effect about them stepping forward and coming and suffering, fear of suffering from retaliation because they have exercised their rights under the Fair Labor Standards Act. And we see some arrangements that could really result in that chilling effect. And that could include these non-compete agreements. This could include other issues that are particularly concerning in terms of, again, empowering workers to make sure that they are getting the rights that they're entitled to under the law. So from the Wage and Hour perspective, we very much look in the course of our investigations to make sure that workers are getting all of the protections that they should be getting under the Fair Labor Standards Act. But we also work very closely with employers to help identify and address areas that could be considered retaliation and prevent those from happening in the first place. And so in some ways, a non-compete agreement really could have that chilling effect, and we're concerned about that for working people.
Yeah, and often these non-compete agreements are unenforceable. Many of them are limited in scope, but they often allow the employer to make certain threats to employees that may not be based in law, because many states, frankly, limit the usage of these non-compete agreements that end up binding the employee to their workplace, even though their agreement actually does not limit their ability to go seek other employment. I guess my only other question is a simple one. I do hope that that we're going to be able to have some success in moving this bipartisan legislation through. If you look at the map of states that restrict them, it has nothing to do with which party controls the state legislature or the governor's office. Again, this is a pretty nonpartisan issue. Just ask for your commitment to work with those of us who are trying to develop legislation to empower the administration to crack down on unjustifiable non-compete agreements. Will you just commit to working with those of us on both sides of the aisle that are trying to address this issue?
Thank you, Senator. Absolutely, if confirmed, I'm happy to continue to work on this issue with you.
Great. Thank you. Thank you, Madam Chair.
Thank you very much. Senator Tuberville.
Thank you, Madam Chair. Congratulations to both of you, and Godspeed to doing this job at this time with inflation, and it just announced that incomes aren't going up very much, and the American people are suffering. But Ms. Lohman, businesses across my state of Alabama and the nation have been hammered by COVID, and we got a lot of rippling effects. It stands to reason that the Department of Labor should recognize the lingering economic consequences that COVID's had on everybody across the country, the negative impact. Many industries are currently facing historic global supply chain disruptions, rising material prices, massive workforce shortages. For example, the construction industry this year will be 650,000 people short, and that's devastating to our country. You know, sweeping change to overtime pay regulations will further complicate and worsen this current situation. Do you think that now is the time for further regulations in this area, just as businesses are trying to get back off their feet? What's your thoughts on that?
Thank you, Senator, and absolutely agree that we are continuing to come out of the challenges that we were all faced under the pandemic. And we do take into account how we think about the work that we're doing, the outreach, education, compliance work that we're doing every day in the Wage and Hour Division in light of all of those issues, particularly focused on essential workers and the workers who really kept our economy going through the pandemic. The overtime issue, as I mentioned earlier, is incredibly important, and it is one of the most foundational protections that we have in this country to ensure that both workers are making the wages that they are entitled to under the law, and also that employers, the responsible employers, are able to compete in the marketplace. When we look at whether or not we want to change any of the overtime regulations, which is something that is our responsibility to continue to evaluate, we look at where we are right now in terms of what the threshold is for an exclusion, to exclude people from the protection of the Fair Labor Standards Act, and whether that's at the right threshold. And as I said, we have been engaging with stakeholders. We have been looking at this issue. We continue to determine whether or not it is the right time to make a change as anticipated by the current regulations. And as you know, the current regulations do set that threshold at about $35,500 a year. And then the anticipated in the most current regulations is this concept that we would need to continue to evaluate whether that is the appropriate threshold on an ongoing basis. So that's the work that we're doing now at the Department of Labor, is doing that evaluation.
Thank you. Ms. Gilbride, you know, you're being nominated for a 4-year term as the EEOC General Counsel. Very important job. As I'm sure you're aware, your predecessor was fired by President Biden last March, years before her term expired. Now, this shouldn't be a political job. This should be a job where people get experience and work through it. You know the problems, you know the answers, and the more and longer you're in this, the better you are at it, and that you're able to help the American people. What's your thoughts about, you know, if any president cut short your term, would you resign?
Thank you for that question, Senator. I would hope that in the time that I would have spent as general counsel before any change in administration, that I would have gained the respect of my peers, and that I would have a track record of success and good work done in the job that would cause the new president to want to keep me on in that position, to gain further experience and to continue my work. If that were not the case, and if a new president came into office and asked me to leave, I would then evaluate whether I thought I could continue on effectively. If I didn't feel I could effectively serve the agency and its mission, then I would step down and resign.
Very good answer. I hope you would tell, I don't care whether it's Republican or Democrat president, to pound sand that this is your job, that you were nominated and confirmed. You know, I'm a believer in experience coming from the field that I came from, so very good answer. Thank you again both for doing what you're doing. It's a sacrifice, and hope you're very successful. Thank you. Thank you, Madam Chair.
Thank you, Senator Tuberville. Senator Casey.
Thank you, Senator Smith, and thanks for chairing this hearing, this important hearing. I want to thank both of our nominees for their enduring commitment to public service. And in particular, Ms. Lumen, I want to commend your work lifting up the voices of workers and the work you did on behalf of members of the building trades. Ms. Gilbride, for your work at Public Justice and advocating on behalf of workers' rights. I'll start with Ms. Lumen. I wanted to thank you for the time we spent discussing the work that you do. I recently, as you know, sent a letter to Secretary Walsh urging the Department to take action on the spread of invasive and exploitative technologies in workplaces across the nation. The implementation of novel technologies to track, monitor, manage, and discipline workers is growing due to an imbalance of power in the workplace and a lack of legal protections or regulatory restrictions on these practices. There are reports that employers are using worker productivity technologies to commit wage theft with little transparency or recourse for workers to understand how these decisions are being made. I believe the Department of Labor must stay at the forefront of these issues on behalf of workers and to monitor and regulate workplace privacy and technology issues before they become the norm. So here's my question. As the administrator of the Wage and Hour Division, how will you consider or weigh the impact of emerging workplace technologies on workers' rights and worker protections?
Thank you, Senator. And if I'm privileged to be confirmed in this role as the administrator, it will continue to be a priority for me to think about how, what tools, what instances, what ways workers may be deprived of their protections under the Fair Labor Standards Act. That, again, is a way that we can work with employers to help identify what those instances might be, where those violations might be occurring, and prevent them from happening in the first place. And so I would be happy to work with you as you continue to think about this issue, to work with the Wage and Hour Division to think about how we can ensure worker protections in light of some of these concerns that you've raised.
Thank you. I'll turn next to Ms. Gilbride to ask you about subminimum wage. As you know, this is a continuing practice that has an adverse impact on people with disabilities. I've worked for years now in the Senate to lead the effort to phase out subminimum wage for people with disabilities. I've got a bipartisan bill with Senator Daines of Montana that would help employers who pay subminimum wage to shift their employment model to a competitive and integrated employment model. There are currently about 1,000 employers across the country that are permitted by law to pay their employees with disabilities below the minimum wage. Some of these employees are paid as little as $1 or 50 cents an hour. The average the last time that it was surveyed is about $3.34 an hour, which is a terribly low wage. Many of these employees with disabilities work side by side with employees that don't have a disability and earn at least the minimum wage. The Biden administration has established the goal of eliminating the use of subminimum wage payments to people with disabilities. Could you please share your policy views on subminimum wage employment from the perspective of the EEOC?
Thank you for that question. This is, I will preface the rest of my answer by saying that the policy position of the EEOC is something that would be set by the commissioners, and I wouldn't want to intrude upon their province. But it is something that I personally feel strongly about and have experience working on. I have litigated a case on behalf of workers with disabilities in New Mexico who were paid subminimum wage in accordance with the program that you're speaking about under 14C of the Fair Labor Standards Act. And we brought that case under state law, arguing that they were not paid in accordance with the state minimum wage. Several states have changed their laws to prohibit subminimum wage employment, and I'm aware of your efforts at the federal level. And as you know, I would be look forward to the opportunity as the role of general counsel would allow, which is primarily a litigation role, but I would look forward to working collaboratively with the Department of Labor, with the commissioners, with others in the federal government, including with your office, on looking at the implications that subminimum wage work and the conditions that people who are being paid less than the minimum wage impose on people with disabilities, and that interface with the equal employment opportunity laws, the anti-discrimination laws that EEOC is charged with enforcing. I would very much look forward to that opportunity.
Thanks very much.
Thank you, Senator Casey. Senator Kane.
Thank you, Senator Smith, and congratulations to the two nominees. Ms. Gilbride, I think I'm going to spend my time talking with you about disability enforcement in the EEOC, particularly with respect to the increase in the number of folks who are experiencing disabling conditions as a result of COVID. Fiscal year 2020, disability discrimination accounted for the second most cited claim of charges in the EEOC, about 36% of all charges filed. The pandemic has been a very large mass disabling event for millions of people. In January, EEOC updated its COVID-19 guidelines, technical assistance, adding a new section to clarify under what circumstances COVID-19 could be considered a disability under the ADA and the Rehab Act. And the update also gave examples illustrating how an individual diagnosed with COVID-19 or a post-COVID condition could be considered to have a disability under the laws of the EEOC, non-discrimination provisions, when they might be entitled to reasonable accommodations at work. I think this is going to be a huge issue for us going forward. It's not all the number of people with COVID-related conditions is very troubling. It's not all bad news, though, because during the pandemic, we learned to do things like telework that we weren't doing before that actually may offer some opportunities for workers with disabilities, and not only those suffering from COVID. But if you were confirmed, how in your role would you prioritize this issue, working across agencies to develop consistent positions about COVID conditions and long COVID with respect to the nation's disability laws?
Thank you for the question, Senator Kane. And I agree with you that the COVID-19 pandemic, and particularly the persistence of long COVID and a large percentage of the population, is something that we're still sort of getting our minds around how that is going to change the workplace, how it is going to change many facets of our society. And I also agree with the point that you made about remote work and how it has really opened up opportunities for people to work in a more flexible way. And I applaud some of the increased flexibility that we're seeing, and I think we're still, again, sort of figuring out what long-term implications that will have for the way that work is performed. I think those opportunities are exciting. And what I would do if I were confirmed as general counsel would be to consult with stakeholders both within the EEOC, and that also is filtering the facts that are coming in on the ground, what sorts of charges are coming in related to disability and COVID, what are investigators and those in the field offices who are handling those charges, what are they seeing? Also to discuss with the commissioners and others on the policy side of the EEOC about sort of trends and the technical assistance that has already been issued and any additional changes that would need to be made to that as the situation continues to evolve. And I look forward to working, across agencies as well to figure out how the government could in a coordinated way sort of adjust and adapt to some of those changing realities that we're still in the midst of experiencing with regard to COVID. And I look forward to learning more and to working with others to craft an appropriate course to respond to that situation.
One of the things that I think is going to be challenging, I was a civil rights lawyer before I got into elected politics and did Title VII and EEOC cases, and the sort of general gravamen of some of our employment laws is we want people to be treated equally at work, and yet not every kind of work is equal. So this committee has grappled with issues, for example, that federal agencies were adopting some uniform policies about telework but that meant that they weren't doing in-person inspections of the facilities that were making infant formula. And one of the things that led to the infant formula challenge was the kind of decision to have a lot of those inspectors do telework because other people in their agencies were doing telework as well. And so for different jobs, telework is great. There are some jobs where in-person is absolutely necessary. Is that treating employees differently? I mean, I think this is really going to be a thorny little area, but the millions of people who are dealing with post-COVID conditions deserve to be treated fairly and deserve to have opportunities to work under reasonable conditions. So this is going to take a focus on fairness, but also a willingness to individualize and be flexible depending upon what the job is. And you have a solid background in this area, not an easy one, but I trust that you'll be able to acquit that responsibility well. Thank you.
Thank you, Senator Kane. Senator Rosen.
Well, thank you, Chairwoman Smith. Appreciate you, and thank you to the nominees for your willingness to serve and being here to answer our questions today. And so I want to talk a little bit about the EEOC report on women in STEM, because I'm pleased that following this committee's EEOC commissioner nomination hearing in May, the commission heeded my call to increase data transparency on incidents of gender bias against women working in STEM fields. In July, it released a wide-ranging report on women working in STEM jobs in the federal government, finding that women account for only 29% of federal workers in STEM fields and only 25% of STEM leadership roles in the federal government. More concerning is that generalized harassment was a significant issue for women, with nearly 2,000 harassment complaints filed in FY 2019. That's why I'm so glad that the recently passed CHIPS and Science Act included provisions I supported to address sexual and sex-based harassment in science. So, Ms. Gilbride, if confirmed as EEOC's General Counsel, how are you going to prioritize enforcement action to improve protections for women working in STEM careers, not only in the federal government, but across the private sector as well?
Thank you for that question. Thank you for your leadership on this issue, which I agree is very important. I'm glad that the report has helped to really shine a light on some of the specific problems that women in the STEM fields are facing in the federal government. And what I would do if confirmed as General Counsel would be to consult with the stakeholders at the Commission and with other people who have expertise in this area, such as yourself, to really understand what some of the pervasive challenges and barriers are. Certainly you've identified harassment as one, which unfortunately is a very persistent and pervasive problem that affects women and men in many sectors of the economy. And I would make combating harassment in the workplace a priority if I were to be confirmed. I think there are several tools that can be used to combat it, including outreach and education and working with employers about how to change climates and be attentive to the climate in the workplace to prevent harassment from occurring or stamp it out quickly if there are reports of harassment. I would also look closely at whether particular charges of harassment can be conciliated and resolved through informal resolution, and would also use the tool of litigation when necessary to try to send a strong message that harassment is not tolerated in the workplace, and that it's something that the agency takes seriously as part of its charge of ensuring equal opportunity. And I would certainly do that with respect to the STEM fields, including other sectors of the economy where harassment is unfortunately still very widespread.
Well, that's great, because we know there is sexual harassment, but there's also hate and violence in the workplace. And so I'd like to talk about addressing the anti-Asian hate and violence in the workplace. So, Ms. Gilbride, I discussed with Ms. Kodegal during her confirmation hearing in May that we've seen an unfortunate rise in crimes and reports of bias-motivated harassment against Asian American and Pacific Islander communities over the last 2 or 3 years. AAPI-owned businesses have been targeted targeted for discrimination, including in my state of Nevada, which is home to more than 21,000 Asian-owned businesses. We're also one of the fastest growing AAPI populations in the country in Nevada. And it's just all too common for individuals in our AAPI community to face harassment, discrimination, or even violence, both inside and outside the workplace. So again, building on what you answered on the last question, if confirmed, how would you use your office to address the increase in anti-Asian violence and discrimination?
Well, hate and violence have no place in the workplace in the United States, and I would take those incidents extremely seriously. And I know that where business owners are targeted, as you mentioned, employers are often the victims of this type of violence and hate, unfortunately, as well. And so I would want to work closely with the employer community and with the Asian and Pacific Islander community and advocates in that community to think as a group about what can we do to be helpful, what could the agency do to be helpful in that space to eradicate that scourge of violence, and because it is not what we want for this country, and I would make that a high priority if I were to be confirmed in this role.
Thank you. I have more questions on pay equity and others. I will submit those for the record. Thank you, Madam Chair.
Thank you, Senator Rosen. Senator Hickenlooper.
Thank you, Madam Chair. And thank both of you. I've been kind of going out seeing little snippets of this, so it sounds like I'm going to have a lot of catching up to do tonight. Ms. Lumen, when I was governor in Colorado, we set up a task force to share information and improve investigations into worker misclassification, and basically what ended up being tax fraud within the construction industry. We did this because law-abiding companies, their workers, I think the taxpayers are being undercut by these, under-the-table payments, and in other ways skirted the law. How do you plan to collaborate and reinforce state efforts in regard to this and other, not just state efforts, but other stakeholder efforts to address worker misclassification?
Thank you, Senator. We currently have in the Wage and Hour Division and are very proud to work with Colorado under a memorandum of understanding. Also a memorandum of understanding, I had the opportunity in Minnesota to work with the Wage and Hour Division to address misclassification. So very familiar with how we can really think about our partnerships with state as a force amplifier, a force multiplier, if you will, in terms of identifying and ensuring that we are providing the best worker protections possible. And I also share that we have really had great success in the Wage and Hour Division and also my work in state government, thinking about how we can address misclassification, wage theft, insurance fraud in the construction industry in partnership with different agencies who have different roles in different types of worker protections. So I think that the partnership, the relationships between states, local government, and the Federal Wage and Hour Division can be really impactful, and if confirmed, I would continue to prioritize those relationships and making sure that we are leveraging all of the worker protection agencies and focus that we can have across the country to really address those issues, to your point, because responsible employers, particularly responsible employers in the construction industry, are very much at a competitive disadvantage when other businesses are misclassifying construction workers as independent contractors.
Yeah, I remember when I first ran for governor of Colorado in 2010, and I heard several stories to the same effect, but the one that just stuck in my mind was a man who was 55 or 56, 57, somewhere in there, about the same age I was at the time, and he had a commercial painting company pretty much his whole life. He'd put 3 kids through college, and yet he was everything above the board. He paid everybody with a payroll check, and he paid the taxes that were owed, and he could not compete. So the changes that happened in the early 2000s drove him out of business, and he was sleeping on the couch in his daughter's basement. And it just, when the people that, the small businesses that have helped create the country we know and love, when they can't compete fairly, I think it's up to the rest of us to make sure we do something about it. I'm glad to hear you're up for that. And collaborating with the states is a great way to go about that. Ms. Gilbride, our team has heard from the Denver field office that their caseloads there are becoming overwhelming due to the understaffing, budget constraints, limited resources. So how important is it, Ms. Gilbride, for the field staff helping the EEOC stop unlawful employment discrimination and the General Counsel's office to litigate cases? I mean, how critical is that? I'm giving you a chance to wax poetic on this. And what can we do to address the staffing issues and really reduce the amount of time it takes to resolve complaints?
Thank you for that question. The field staff are on the front lines of the agency's efforts to make sure that the workplace is fair and inclusive and a welcoming space for everyone. And if they don't have the resources that they need to do their job, then, unfortunately, workers who are relying on the EEOC are the ones who suffer for that. And so what I would hope to do if I were confirmed as general counsel would be to talk to all of the regional attorneys in the field offices and really get a grasp for what are they dealing with, what are the challenges, and what are their needs. And what can I do as head of the Office of General Counsel to make sure that they have what they need in order to do their critical work on behalf of America's workers.
Great. Perfect. What was the name of your dog again?
My dog April is
your dog April. There's, I guess, no way we get the camera to
table
show April, who's faithfully sitting at the feet of her masters. But obviously, you'll be a dynamic team. I look forward to working with you.
Thank you so much, Senator.
Thank you, Senator Hickenlooper. Do any other members have any questions, any additional questions they'd like to ask? Well, in that case, thank you to our nominees for being here today and for providing your testimony. For senators who wish to submit questions for the record, those questions are due 1 week from today, which will be Tuesday, September 20th. Again, thank you to our nominees for being here today. And with that, this hearing is adjourned.